How far can a state go to disqualify a presidential candidate from its primary ballot? This question took center stage when, on a late December day in 2023, Maine's Secretary of State, Shenna Bellows, made a groundbreaking decision. She ruled that former President Donald Trump was disqualified from appearing on the state's primary ballot. The basis for this ruling? Section 3 of the 14th Amendment of the U.S. Constitution and Trump's role in the January 6, 2021 assault on the U.S. Capitol. Bellows, a Democrat, argued that the Constitution does not tolerate an assault on the foundations of our government, and that her duty required her to act in response. This decision was not made lightly, nor without the opportunity for appeal. In fact, Bellows suspended the effect of her decision until the Superior Court had a chance to rule on any appeal. But why the rush to make such a decision? Bellows explained that under Maine law, she was required to issue a swift decision, and could not wait for the United States Supreme Court to intervene. Her ruling was based on the evidence and facts presented during a hearing. However, this doesn't mean that Trump's name was immediately scrubbed from the ballot. Bellows made it clear that no ballots would be printed until the Superior Court made a decision. This ruling was a first of its kind. Never before had an election official unilaterally made a decision on a candidate's eligibility. It was a process that required voters to first petition the Secretary of State with challenges to a candidate's qualifications for office. After that, a public hearing was held where the challengers had to argue why the primary nomination should be invalidated. Bellows acknowledged the unprecedented nature of her decision, saying, "I am mindful that no Secretary of State has ever deprived a presidential candidate of ballot access based on Section 3 of the 14th Amendment. I am also mindful, however, that no presidential candidate has ever before engaged in insurrection." As expected, the Trump campaign announced it would appeal the decision, calling it an atrocious decision in Maine, and an attempted theft of an election. This ruling in Maine came hot on the heels of a similar decision by the Colorado Supreme Court, which also ruled that Trump was disqualified from its ballot. That decision too was stayed pending an appeal to the U.S. Supreme Court. In summary, Maine's Secretary of State, Shenna Bellows, made a historic decision to disqualify former President Trump from the state's primary ballot. This decision, based on the 14th Amendment and Trump's role in the Capitol assault, has been suspended pending an appeal to the Superior Court. As we move into the new year, we watch with bated breath to see how these unprecedented legal battles will unfold.